Hello and welcome to this bite-sized training session hosted by Farrar's building. My name is Tom Emslie-Smith and I'll be spending the next 10 to 15 minutes or so discussing the basic principles of writing defences. And we're going to be looking in particular at some do's and don'ts with a view to writing the best, most impactful defences that you can. To my mind, defences are designed to do three things. Firstly, a defence is there to narrow the issues. It needs to tell the court what is and isn't in dispute. The second thing a defence does is it raises the points that the defendant seeks to rely on. So certain things can't be relied on by the defendant unless they've been pleaded in the first place. Thirdly, and this is the point that's sometimes missed, and this, to my mind, distinguishes a good defence from a bad one, is that a defense communicates the essence of the defendant's position. It's probably the first document that a judge will read. So a good defense will communicate clearly and forcefully what the defendant wants the court to conclude. A bad defense will leave you none the wiser as to what the defendant is really saying about the allegations that are made in the particulars of claim. So as a starting point, the rule in the CPR that tells us what a defence is there to do is Rule 16.5. In subparagraph 1, it says, in his defence, the defendant must state which of the allegations in the particulars of claim he denies, which of the allegations he's unable to admit or deny, for which he requires the claimant to prove, and which allegations he admits. So there are three things you can do. You can admit the allegations, you can deny them, or if you're unable to do either of those things, can require the claimant to prove them. If the defendant denies an allegation, he needs to state the reasons for doing so, and if they intend to put forward a different version of events from that given by the claimant, the defendant needs to state their own version. So not only does the defense need to say which of the allegations they agree with, the defense also needs to put forward the positive case that the defendant wants to rely on. Subparagraph 3 of that rule tells us the consequences of failing to deal with things in the defense. So firstly, it says, a defendant who fails to deal with an allegation, but has set out in his defense the nature of the case in relation to the issue to which that allegation is relevant, shall be taken to require that allegation to be proved. Where it's a money claim, the defendant is taken to require any allegation about the amount of money to be proved unless it's expressly admitted. But here's the important part. Subject to those two paragraphs, a defendant who fails to deal with an allegation shall be taken to admit that allegation. So it's really important that it's a comprehensive response to every single allegation that's made in the particulars of claim. If the defendant doesn't deal with something, say whether they deny it or require it to be proved, then they'll be taken to admit the allegation. The rule goes on, and subparagraph 6 is something that's often missed. If the defendant disputes the claimant's statement of value in Rule 16.3, then the defendant must state why he disputes it. And if he's able, give his own statement of value of the claim. So this could be relevant, for example, if it's a case where the allegation is that the claim is overinflated or exaggerated. That might be very helpful to comply with that rule if, for example, there's going to be a dispute as to the track that the case should be allocated to, or if, for example, the allegation against the claimant is that they've dishonestly inflated the value of the claim. And for completeness, we'll just look at the two last parts in that subsection. If the defendant is defending in a representative capacity, he must state what that capacity is. And if the defendant has not filed an acknowledgement of service under Part 10, the defendant needs to give the address of the service in the defense. So that's the bare bones of what a defense needs to do according to the CPR. We're going to move on now and look at a few do's and don'ts for how you would write a good defense. So the first point that's really fundamental for me is you need to do as much of your investigation into the case as you can before you start drafting the defense. In order to write a good defense, you need the facts at your disposal that you're going to use to address the allegations in the particular claim. Remember that denials require supporting facts. So if you deny something that's said by the claimant, then you need to say why you deny it. And if you have an alternative case, then you need to set out what that alternative case is in the defense. If no investigation has been done into what's said by the claimant, then you won't have the facts at your disposal to dispute anything that the claimant has put forward in support of the case. And then, as well as addressing the allegations that are made against the defendant, you want to be in a position to advance a positive case in the defense. That's going to be much more forceful and is going to strike the judge as a much stronger case than a defense that's devoid of anything that is said in support of the defendant. So in order to put yourself in the position to be able to do that, you need to obtain as many facts as possible that can strengthen your defense before you begin to draft it. So by way of example, say you're acting for an employer in an employer's liability claim. You want as many facts as possible to show that your client has done everything that it reasonably could to ensure a safe system of work. So for example, method statements or risk assessments or steps that they've taken to mitigate risks. If you don't have those facts at your disposal, then they can't be set out clearly in the defense, and it's going to be a less impactful document. Once you have those facts at your disposal, make your factual assertions really clear. So again, you want the judge to be able to read your defense and have a really clear idea in their mind exactly why they shouldn't enter judgment for the claimant, as is set out in the particulars of claim. So make the factual assertions really easy to read. Think about the way that you're phrasing them. And it might be a case of breaking down different factual assertions into appropriate paragraphs or subparagraphs. And a related point is just make sure that you communicate compellingly in the defense. You want this to strike the judge as the stronger case. So think about the way that you're phrasing the allegations that you make against the claimant and the reasons why the defendant has acted reasonably. You'll remember you can either admit facts, deny them, or require them to be proved. And it's very helpful where facts do fall to be admitted, that if the defendant admits them. Not only does that narrow the issues and tell the court actually what they have to decide, but it also comes across as a defendant that is able to admit the parts of the claimant's case that are correct. And that's going to mean that the parts that are in dispute come across much more forcefully. But there are two qualifications to that. There are some things you can do to put meat on the bones of any admissions that you make. So first technique is you can admit and aver something. So if something that's said in the particular claim actually supports the defendant's case, you can say it's admitted and averred that so-and-so happens. The defendant's then on the front foot in regard to something that's admitted from the particular claim. The second thing you can do is you can admit something, but you can add qualifications to that admission. If there's something that's said in the particular claim that's correct, but there's perhaps more to it, or there are things that you need to nuance or qualify in order that the court understands really what happened, then you can say, for example, such and such is admitted, but that's subject to the following averments, and add any qualifications that would be helpful for the court to understand your case on that point. The fourth thing that a defense must do is raise any specific defenses that you're relying on. Remember, certain things that aren't set out in the defense at the outset can't be relied on by the defendant. So by way of example, limitation is a defense that needs to be pleaded. If limitation isn't raised in the defense, then it can't be relied on by the defendant. But not just limitation, think of any common law defenses that go beyond simply requiring the claimant to prove their case or go beyond simply the factual dispute at hand. So things like the defense of volenti, the voluntary assumption of risk by the claimant, that's a common law defense that needs to be pleaded in the defense in order for the defendant to rely on it in its defense of the claim. Similarly, a defense like illegality would need to be something that the defendant raises in its defense. And the third bullet point there, I've just used by way of example as something that needs to be pleaded, but it's commonly missed. So the manual handling regulations, if it's the employer's case that it wasn't reasonably practicable to avoid manual handling altogether, then of course they need to show that they lowered the risk of manual handling to the lowest level reasonably practicable. Now, if they don't plead that it wasn't reasonably practical to avoid manual handling altogether, then they can't rely on that in their defense. The case law is very clear on that. So that's the sort of example where there are features of the case that the defendant has a duty to plead. So if there is any sort of feature that might not be entirely common in the case, do take advice, do think very carefully about what the defendant needs to set out and make sure nothing is missed. Just on those points, Practice Direction 16 gives a little bit of help as to what needs to be pleaded. Firstly, paragraph 13.1 says the defendant needs to give details of the expiry of any relevant limitation period. And then 13.2 refers to a defense of tender and refers to Rule 37.3 for the specific requirements as to that. So that deals with specific defenses that need to be raised. My final point is, if it's appropriate in a particular case, then make sure that you plead any alternative case that you might have to rely on. So for example, your primary case might be that such and such happened, but there's a chance that the court could find against you on that factual issue. In some cases, you'd need to plead a case in the event that the court is against the defendant on that particular issue. Here's what we say about the remaining issues in the case. So make it really clear what is your primary position, and then say, without prejudice to that primary position, should the court find so-and-so, then it will be the defendant's case that such and such. So those are some of the things that you should do in every defense. Here are some of the points that you should avoid doing. Firstly, avoid slavishly following your precedents. Now, I'm sure that most, if not all of you, use templates or precedents to draft defenses. Now, that's a perfectly reasonable practice and very helpful and time-saving, but don't slavishly follow every suggested line in every case. There are a number of pitfalls in that. It means that things are missed, and it means that things are phrased in a clumsy way. There may well be a better way of phrasing something that puts it more clearly and makes the defense a much better document for the judge to read. So don't slavishly follow a precedent. Think about the way that things are coming across, and think about what might need to be pleaded in addition to what's set out in your template. Second thing not to do is just to put the claimant to proof on everything. So the case law is very clear that you should only require the claimant to prove something if you're not able to admit or deny something. So if you have the material to put forward in a denial, that's what you should do. Or if it's something that needs to be admitted, that's what you should do. Defenses that are just full of requirements that the claimant prove his claim are not particularly impressive defenses. And in practice, it's a lower standard for the claimant to meet. If a forceful positive case has been put forward by the defendant, then that's going to strike the judge as a much more powerful case than simply a requirement that the claimant has to prove their case on this or that issue. The third thing that you mustn't do is plead a case that's inconsistent with your client's own evidence. I hate to think the number of times that a defense has actually become a weapon in the hands of the barrister for the claimant, because it's inconsistent with something that's in the defendant's own documents. So before you draft the defense, look at the document very carefully. Make sure that the factual case you're setting out in the defense doesn't contradict anything that's said somewhere in a document, and make sure that it doesn't contradict what's said in your client's own witness evidence. Make sure everything is consistent so that there aren't discrepancies that can be picked up on in cross-examination. Those are the things you mustn't do. There are a few things that are permissible, but don't represent particularly good pleading practice. So first thing we try and avoid is pleading evidence. So there's a difference between pleading a fact and pleading the evidence that you're going to use to establish that fact. Defences and particular claims shouldn't just be a list of evidence that the parties are going to rely on. They should tell the court what the facts are that the parties are going to invite the judge to find. And similarly, avoid making submissions, legal points, or arguments in the defense. Stick to the facts that you want the judge to find. So just on those last 2 points, practice direction 16 is relevant here. So paragraph 13.3 says that a party may refer in his statement of case to any point of law on which his claim or defense, as the case may be, is based. So it is permissible to raise a point of law in the defense. And sometimes it's important that you do so if it goes to the heart of what your defense really is. Secondly, you can, in your defense, name any witness that you propose to call. And you can, paragraph 3, attach or serve a statement, a document that you consider necessary to the defense. So all these things are permissible. But my advice is to use those things sparingly. Really what a defense should do is set out the facts really clearly and make it clear what the essence of the defendant's case that they wish to advance is. So thank you very much for watching. I hope you found this session useful. Please do refer to the knowledge base section of our website for further bite-sized basic training sessions on different topics. And if your team are interested in receiving more in-depth personalized training, then do get in touch with our marketing manager, Kelly, and she'll be able to discuss any requirements that you might have in more detail. But thank you very much for listening. My name again is Tom Emslie-Smith, and thank you for joining me.